Hey, good afternoon, everyone in family law. Due to popular request, I'm going to put up a short video combining chapter 7 and 8. One is alimony or spousal support, and the other is the division of marital assets. Although I think the book does a really good job and it's very accurate and I think fairly clear, some students wanted to have a video on it, so I'm going to put it up. I just got back from work and I'm sitting with my two dogs. Martha, Martha, how do I do that? There's Martha. Oh, Bailey had to come over. That's Bailey over here. So, Bailey, what you doing? So, I'm dog sitting tonight down here in the living room, and I thought I'd put up these videos for those students that want to at least hear some outlines of the rules when it comes to spousal support and the division of the marital estate. Spousal support is also called alimony. Massachusetts did a huge reform in 2011. It really changed the eligibility in the length that a person would likely have to pay alimony and the length of time somebody might be able to receive alimony. But let's just start off, what is alimony? There's 4 types in Massachusetts, and of course I have notes on this on my phone here. So one is called general term. It's alimony for a spouse who's economically dependent. The other is rehabilitative, which is alimony to support a spouse until they can support themselves. Reimbursement alimony is to pay a spouse back for contributing to the financial well-being of the other spouse that's ultimately going to be the payor. And then the last one is transitional alimony to help a spouse adjust to a lifestyle that divorce has changed. Under all 4, there's a similar analysis on whether someone's eligible to receive alimony and whether or not someone has to pay it. The goal is not to hurt the payer and take them and lower their station in life. The goal is to make sure that upon a divorce, one party is not so diminished from the station of life that they're accustomed to create an unequitable situation. Not equal. We don't expect equality out of divorce. Divorce is a financial hardship, usually to both parties, and there's usually going to be some kind of lowering standard for both. But the critical aspect is we don't want one person to leave a certain station of life so dramatically while the other one still lives sort of in the high life. That would be unequitable, especially if the marriage has a certain degree of length. In Massachusetts, the degrees of length of marriage are basically 0 to 5 years. There's no eligibility for alimony. So if you have a marriage that's less than 5 years, there's no eligibility for marriage whatsoever. It gets a little bit more complicated, however, when it's a 5 to 10 year marriage. There, it can be no more. The payer doesn't have an obligation beyond 60% of the number of months of the marriage. So if the marriage was 10 years, 60% of 10 years would be basically 6 years of alimony potentially. And then 10 to 15 years, it's no more than 70% of the number of months of the marriage. Then if it's 15 to 20 years, no more than 80% of the number of months of the marriage. And if it's 20 years or more, a very lengthy marriage, it's indefinite. Doesn't mean it's permanent necessarily, because there are certain triggering factors, like the recipient no longer really needing support, or the payor not being able to pay without becoming impoverished themselves. But it's an equitable principle. A lot of people think like, well, I'm getting a divorce, I don't want to pay alimony. Well, you may not have to be if the parties haven't sort of an ability and the wherewithal to stay in the economic realm that they were accustomed to during the course of the marriage. It's sort of a common sense application when you think about it, the factors the court looks into. But I want to give you one of the famous cases that came out right out here at Sturbridge that involved a friend of mine's parents. They were married for a very long, this is before alimony reform in 2011. And what did alimony reform do in 2011? It basically limited the length of the eligibility to receive. It no longer should be considered to be really this permanent support system for the payee by the payor, unless it was for a lengthy marriage. But going back to the example that came out of Sturbridge, that became a fairly famous case, the husband made significant money, 6 figures multiple times, so hundreds of thousands of dollars a year. This is back in the 1980s. And the wife was a stay-at-home mom, 6 children. And those of you that are a parent and are responsible for the daily upbringing and chores related to raising children know that's nothing to shirk about in terms of the contribution of that person's role. And after a lengthy marriage, probably over 30 years, they divorce. And the husband maintains a very, very healthy, really a massive income, if you ask me. And the wife never worked, and she gave up career opportunities and didn't have any. Talk about being rusty in terms of what it was like to go out and work in retail or anything else. And if she did, she'd probably be making very, very low income at the time. He's living high off the hog with huge amounts of income. He doesn't pay child support because the kids are all grown and all adults now. And she is going to be left in a situation where, although she did receive the house in the next chapter, the division of marital assets, she gets the house, but there's real estate taxes, there's upkeep, there's food, there's electricity, there's utilities. How is she going to come up with cash? And the common sense approach would be the husband should probably contribute some support to the wife for a period of time, some kind of either rehabilitative alimony or really their general alimony for probably a fairly lengthy period of time. These were fairly elderly people at this juncture when they were getting their divorce. And I know this sounds like a little bit of a weird story, but after alimony was awarded, it went all the way to the Superior Court, the appellate court in Massachusetts, helping define the eligibility when it was appropriate to alimony. And it's a totality of the factors: contribution, people's ability to earn income, their past ability to earn income, their college levels of degrees and skills, and the like. It's very similar to the next chapter. That's why I've combined the two in determining the equity of the situation and whether one party should pay some kind of support. That's just what it is. It's support to make sure that the other party has a certain degree of well-being so their station in life doesn't deteriorate dramatically vis-a-vis the end of the relationship. Alimony is very, very controversial, and it was controversial in Massachusetts because many people are getting permanent alimony, and that would last for decades and decades, even on fairly short marriages. And that's why the Reform Act was so popular in 2011. The statute now forces the court to have windows of awarding alimony. The only time it gets really, I would say, a little bit unpredictable in terms of the length of the payments that might be due relate to a very, very long-term marriage over 20 years. And again, it's not permanent after 20 years. It's just indefinite. And the court will look at things like what's the likelihood of the other person to be able to become retrained or go out and find a career at maybe a later juncture in life. And when they look at those factors, and of course, there's need involved too. If both parties are extremely wealthy, whether it's from income, inheritance, trust funds, or whatever, alimony might not be appropriate. The court looks at the totality of the circumstances and what's the sort of the ground floor rubric that we're going to use. We don't want one party dropping down to a very significantly lower station in life as a result of the divorce if the other party is still going to be able to maintain a very high standard of living. We want it to be equitable. One's probably going to go down some, but we don't want one to be really left a ward of the state in terms of welfare benefits and public assistance when they were accustomed to living the high life. And the example I used to give when I taught this class live and in class was husband and wife get married. They get married in their early 20s. Wife has an ambition to go on to become an orthopedic or an orthodontics doctor, and she goes and gets advanced degrees in dentistry and dental surgery and all of those kinds of things, while husband supports her financially, and then they have children, and he's the stay-at-home dad, and he supports the home and supports really the ability of the wife to go out and earn substantial income. And as the marriage goes on, she becomes a very, very successful orthodontic practitioner and has doctors working under her. She has a complex practice with many different employees, and she's really raking in the dough. And they have a beautiful home together. They take vacations together. They have fine clothes and fine food, and all those kinds of things get developed because of the wife's income, but because the husband also contributed to that opportunity. Now they decide to divorce. The kids are grown. There's no child support eligible because the kids are emancipated and grown up. All of a sudden, the wife says, okay, I'll see you later. I'm still going to be making my $350,000 a year. Husband has a high school diploma, and not that he doesn't have a sharp brain and all those things. he clearly is going to need some support for a period of time. And it would be fundamentally fair to allow him to get some money from his now ex-wife for a period of time so he can either become rehabilitated and get further education or job skills and get on his feet, or maybe just general alimony for a period of time because of all the contribution, or maybe some of it being what? Retroactive contribution, if you will, in the sense that he had made the opportunity available for his wife to do those things. And I always try to switch the parties from time to time. I talk about class because I don't want to sound like I'm sexist, that it's always the man paying alimony and it's always the woman receiving. It's not that way at all, especially today. In modern America, that many women earn their wives, and some men are taking over the traditional roles as, the primary caretaker at home. And so that's the kind of analysis we get into with alimony. One of the things that did recently change is alimony used to be deductible for the payor under federal tax code. And so sometimes when couples were divorcing, they would try to shield or benefit from the tax code by saying, hey, let me pay you a little less in child support or a little less in the division of marital assets, and I'll send money over to you monthly. We'll call it alimony, so I get to deduct it on my taxes. The only problem with that on the other end is the recipient used to have to claim it as income. But sometimes that's not the worst situation. If that's all they have for income is alimony, it might not necessarily be anything where they'd have to pay into the system. So they would be basically ripping off the government, the tax code, by cloaking the division of marital assets or child support in the form of alimony. And IRS had a lot of, they would investigate to look for that. It's no longer the case. It's not deductible under federal income tax policy anymore, and it's not includable in the income anymore by the recipient under federal law since I think 2018, 2019, somewhere around there. But under Massachusetts state law, under the state tax system, it is deductible by the payor and includable in the income of the recipient. And again, there's a much more stronger formula in Massachusetts for the length of time. When I used to do this stuff, I didn't do any around 2011, but I was affiliated with attorneys that did, and they would have software actually to determine the length of time that a payor may have to pay child support. It doesn't mean the judge has to give that specific formula. You've married 7 years, we're going to do 60% of the 7 years of marriage, and that's how much the recipient, that's how the maximum could be. So we know what the window would be for. How about the amount? The amount is not fixed by statute. The amount is whatever the court deems to be appropriate, and maybe none to be appropriate because the other spouse has assets and wealth and other means, so it would be inappropriate to order alimony. It's a holistic approach. It's a holistic review. And like in many things in family law, there's a certain degree of unpredictability. It's number crunching and gathering of information and convincing the judge, it's not a jury trial, we know that in probate court, of the equity of the situation when it comes to alimony. I'm just going to flip through her book. And this author is from Massachusetts, by the way. I didn't see her mention specifically Massachusetts. Yeah, factors to consider: financial need, earning potential, age, duration of marriage, physical, mental health, and anything. One might be impaired and physically or mentally, and obviously it'd be more equitable to allow that person to have continued support because they're obviously not going to be able to become self-sufficient potentially because of physical or mental limitations. Marital standard of living, contribution to the marriage. And I think that's the biggest one that they look at is contribution. Who did what in the marriage? So go back to my orthodontic doctor again. Let's assume they didn't have any kids and the orthodontics doctor put herself through dental school and all the rest while the husband was out playing golf and surfing and just having fun. She tolerated it during the entire course of the marriage. But it's a 10-year marriage, and he basically lived the high life during that period of time, and she did everything to contribute to the purchase of the home and to the nice clothes and to the food and things like that. Equity would suggest that if he does get support, it'd be rehabilitative, and it would probably be for a fairly short duration because of the conduct during the marriage. And this is one area where they do look at conduct, especially financially, in terms of who did what to contribute, in terms of the ability of the family to gain its income status. Because at the time, before the time the marriage ended, they looked at it as, we don't look at one or the other. This is the ball of money coming in as the married couple. How are we going to, are they just going to go to one side 100%? Even in that situation, that sort of deadbeat, happy-go-lucky husband who never really worked a day in his life probably would get some alimony in a lengthy marriage, 15, 20 years, especially if he had no job at the moment of divorce and he was accustomed to living in a very high standard of living. But it's probably not going to be a very lengthy period of alimony, and the amount that's awarded might not be a large amount. There's a certain degree of unpredictability. Alimony is still somewhat even unpopular with the courts, I would argue, because oftentimes the division of the marital estate, which is the next chapter I'm about to segue into, often is sort of the preferred method of resolving the marital claims between the parties. So sometimes the one that's making more money will let the other party that has less economic viability to receive more of the marital estate to create an equitable ending of the relationship. I'm getting way too deep into alimony. Medical insurance is considered with that. Oh, remarriage in Massachusetts actually has a presumption in law that if someone is cohabitating for more than 3 months, alimony should end because they have a new economic viability with their new partner. For a long time, it wasn't clear even on remarriage whether or not it would end alimony. Now, remarriage definitely does, but cohabitation creates a presumption that over 3 months that marital support or alimony should end. I don't know how you prove cohabitate. I mean, people get very bitter and they hire investigators and things like that to determine cohabitation. But the cohabitation there's still an evidentiary hearing. Does the cohabitation really create a new economic stability for the recipient of the money? So remarriage, death obviously ends alimony. Premarital agreement would take care of this whole thing if it's a valid prenuptial agreement. Now the next chapter, which I think is very, very difficult sometimes for students and for clients, maybe the public as a whole, to understand the two different kinds of systems that exist out there. Oh, by the way, these alimony rules that I just talked about are exclusive to Massachusetts. Other states have very different alimony principle. The principle is still the same, but the length of availability and whether cohabitation or whether remarriage ends the obligation to pay or receive alimony might be different in other states. I'm just kind of talking about the Massachusetts principles on the alimony there. The next chapter on the division of marital estate, we live in what's called a common law state or an all-inclusive state. So the day you get married, everything you own, your spouse now also owns as a married couple. That shocks people. So wait a minute, no, that was the car I bought when I was in high school and I saved up all my money from all those summer jobs and my dad paid for half of it. That's my car, my GTO, my 1964 GTO with a big block engine. That's mine. Well, if you don't have a premarital agreement, it's a marital asset. That doesn't mean the spouse is entitled to 50% of its value or equity. It just means we have to consider that as part of the marital estate when we divide it later. We're not necessarily dividing in half. And that's what troubles people or gets people very confused. So in a common law state or an all-inclusive state, we have to consider everything. Inheritance, gifts during the time of your lifetime while you're married, prior, all of it comes into the marital estate. And then we have an equitable distribution. And just like in alimony, what does equitable distribution mean? Well, let's assume I did have that GTO car and it's worth $50,000. I'm the one that saved up all the money and got gifts from my dad to help me buy it. And then upon marriage to my wife, we're married, say, for 10 years, and we decide to call it quits, the court will examine things like, well, who bought the GTO? Who put money into it? Did the wife over the 10 years help pay the insurance premiums on the car? Did she ever go out and help, and contribute finances to the oil change and the upkeep and the storage of the vehicle? And things like that start suggesting that if she did those things, maybe pay the excise tax on it each year out of some of her funds, paid the insurance on the car over the years, paid for oil change and mechanics bills with contribution from her income too, that it should be a portion of the value will be equated to her having an interest in it. And so but we don't look at just one asset, we look at all the assets. But we consider things like that. And so sometimes when I used to do a lot of divorce work, I'd have somebody come in and the wife would hire me, and you can't do both, by the way, a very strict ethical rule. A lot of people think, well, they're getting along and they have an agreement for everything. You can represent both. Not in Massachusetts, you can't, because it could break down and then you can't represent either because you've gotten confidential information from both clients. But let's assume I'm representing wife. She comes in and she goes, this is the house we live in, and we're in total disagreement. We hate each other now. We're getting a divorce. There's no abuse or adultery or utter desertion or chronic alcoholism. None of the fault grounds are there. It's just we just hate each other. The wife says, "Well, I'm a divorce, and we're both still living in the same home. I want him to move out, and I want to retain the house because it's mine, and my name's on the deed, not his." Well, names on deeds and names on title don't really mean anything at all to the probate and family court. And I'll say, well, so you have to do this. That's why paralegals are so valuable in a family law setting, because there's a lot of investigation and questionnaires that need to be really answered. And one of the questions I would have is, how'd you get the house? He goes, oh, I inherited it 25 years before I met my husband. I'm like, okay. Did you get it with no mortgage on it and any encumbrance? No. Okay. And prior to marrying it, did you do any upkeep or pay for anything in the house? Well, yeah, we put a new roof on and a new boiler before I married Fred. And after you married Fred, you lived together for 10 years. Did Fred ever help pay anything with regard to repainting the home, putting additions on, putting new windows on, help with the real estate taxes? And there's always inevitably some contribution towards the maintenance. So now it becomes what we think of as a kind of a commingled assets. There's no independent exclusive unless you had a prenuptial agreement. It's just the way it is. Even though the deed's in her name, even though it came in through her realm, if you will, prior to the marriage, that's part of the inequity analysis. And will the court likely award her the house? Yeah, but will they probably award some financial contribution out of other assets to the husband based upon the commingling of sort of the efforts to preserve, protect, and enhance the value of that home over the years? And maybe when she got the home 10 years before marriage, it was valued at $300,000, but during their 10 years of marriage, it went up to $400,000. Shouldn't the growth in the appreciation of the asset be somehow shared in an equitable way? See how hard it is? It's really difficult math. And people are shocked when I tell them, yeah, I know you own the house beforehand, but it's part of the marital estate. And you go, oh, but it's in my name. My wife, the house I'm in right now is in my name alone. And at the time I bought it before marriage, so my wife is always thinking, well, this is your house. This is your house. I'm like, no, it's our house. It's the marital house. Goes, but my name's not on the deed. If we get a divorce, I'd like to think she'd be naive enough to say, well, I can't go after anything to do with the house because my name's not on the deed. But I tell her all the time, no, it's a marital asset. If we ever were divorced or I were to die, you would have an interest in it because Massachusetts is a whole state or all-inclusive state. It's a common law state. And during the time of the marriage, the court would do an analysis like helping pay the real estate taxes, having new roofs put on, having the whatever pool thing done, or whatever. All of those things get considered in a division. And so I find it I don't want to say unpredictable, because I've gotten pretty good at figuring out the longer the marriage, the more likely the court is going to divide fairly equally the assets of the relationship, unless there's really unusual circumstances. So you have a 40-year, which is really bizarre when people are married 40 years and they get a divorce, but it happens. But let's say this is a 25-year marriage. Usually I say we got to figure out everything, marshal all the assets, figure out a bottom line, and then try to divide it pretty close to 50-50, unless there's been bad conduct. And that's why we still have fault grounds for divorce. If one party was really, desertion or cruel and abusive, then there might be more of an equitable argument that the wrongdoer should get less of the division of marital estates. And that's why we still have fault grounds argument. Adultery doesn't have any play on the division of marital assets. It's not really considered a fault ground. It's there for purposes of ending the marriage, but it doesn't give you an advantage if you're the victim of an adulterer. And it's controversial, but I didn't make that decision. The court of law says the failing of a heart shouldn't have any impact on either child custody or to the division of marital assets or alimony. So there's a little bit of unpredictability over this. How do you avoid don't marry or have a prenuptial agreement? The ending of the marriage, if the parties, most parties do, over 95%, they don't think they will, but they get pressured by everyone, the attorneys, the courts, everybody pressures the parties because your situation best. You know what's equitably best between you and your future former spouse, how to divvy up the assets. And if you don't agree, you're going to get a judge that's going to hear the case over a few hours and determine very life-changing determinations about your financial situation, where you know best what would be equitable. So the parties really, and that's why it's a growing area of mediation in this area, to get a mediator to kind of look at it, or an arbitrator. Well, arbitrators give a judgment. It wouldn't be an arbitrator, it'd be a mediator, really try to hash out what would be fundamentally fair. And parties sometimes feel a little bit better about coming to an agreement. So prenuptial agreement is just that. Prior to get married, what will happen with all of our assets and our legal obligations financially. A postnuptial agreement is your separation agreement, or your divorce decree of how things will be divided. Most people come to an agreement. And sometimes if you look at old divorces in Worcester County, Hamilton County, it doesn't matter where, you'll often see them handwritten, portions of it handwritten. It's because they agree on the day of trial, and the judge wants they want a separation agreement right now, because that's going to become incorporated into the judgment of the court. And you'll see them written out on yellow pads. One attorney, some of you may take him for a class, Lee Howard. He works full time for the Committee for Public Counsel. I think he does mostly the family law related stuff with kids and stuff, but he used to do divorce work. The one thing, many things I'll give him credit for, but I watched him divorce. He would type up a separation agreement with all those sections, because most couples, we agree on X, Y, Z, but we're not agreeing on A, D, and Y in a divorce. Probably combine a few letters. My point is, they agree on a lot, but they don't. So he would have those sections all typed up. And that way it would create a more formal looking document and more clear. And then he would just have the sections of the portions that were still in dispute. So if they did come to an agreement, they could handwrite only in those sections. It's a really, I thought, a very thoughtful way to practice, because it's usually boiling down to one or two things, like retirement account, or, a buyout. You want to keep the house. Well, I want to keep the house. Well, one person, one that maybe is going to get primary custody is more likely to keep the house. But that doesn't mean the other person shouldn't get some equity out of it. And how are they going to pay that equity out? Are they going to get it refinanced, or are they going to do payments over time? The court wants it resolved, so they don't like it when it's like keep the case open. So they try to refinance within a certain window, and if they can't refinance, maybe some other assets can be exchanged and things like that. It's a real nightmare. And I remember one of my first attorneys, I worked for a large law firm the first time out of law school, and I was working with this one attorney. He was telling me about a divorce he had done, where literally the night before they went to court, they were coming to an agreement. They were doing things like, one fork, they had, I guess, a nice silverware set. They were like, okay, one fork for you, one fork for him. But it was that bitter and that difficult to come to a conclusion. And that's where I think good attorneys, ethical attorneys, really should try to work together to try to figure out what is equitable and divvying it up. So what factors does the court look into? Everything. Just like in child custody, it's a holistic look. The number one thing they look at is contribution. Who did what to help garner, grow, acquire the assets, including contribution also relates to caretaking of children. That's a massive contribution. It's probably the most important in many respects. So a lot of people think when you think of contribution, it's about money contribution. It's about making the family move forward, having economic viability, and nothing can be more important than raising kids. So I don't want to make it sound like that's diminutive. It's not. It's huge. But most people, when they think in that word contribution, they think those. And I don't know if the book has it written out. It's the same statute that governs alimony. Chapter 208, Section 34 has all the factors in Massachusetts. But the book does a nice job talking about the different factors. At least I thought it did. Property classification, again, a classification everything. And every so often, I'll, in the homework, I'll see things like, well, anything that you acquired during the course of the marriage, that's a marital asset. Yes, that's true, but also everything you had prior to getting married is in the marital estate, unless you had a prenuptial valuation. Yeah, here it is. Consideration of specific duration of the marriage. That's a big one. The shorter the marriage. So my wife and I have been married for 3 years. I know because I forgot our anniversary and it was recently. So if we had a divorce today, there would be I just lost my train of thought. There would probably be a situation because of the shortness of the marriage. She would probably keep mostly everything that she brought into the marriage, and I would keep mostly everything I brought into the marriage, because the assets were clearly, we can identify who brought what to the table, and there's been very little transmission, if you will, kind of, she didn't do a lot to preserve, protect, and enhance the assets I brought to the marriage, and I didn't do much to enhance, preserve, or protect the assets she brought to marriage. We haven't yet, kind of became a melting pot of a married couple that the length of a 20 or 30 years marriage would have. And so the shorter the marriage, the easier it is, I think, for the court to figure out how the division of marriage shall occur. The age, physical, and emotional health of the parties. Obviously, if one party is much younger, maybe they shouldn't receive as many of the assets because the older person might not be able to go and earn income or have the health and well-being to go out and do it. Income or property brought to the marriage, standard of living established during the marriage, any written agreement, well, that's a prenup, the economic circumstances of each party, income, earning capacity of each, contributions number one. I don't know why they don't stress that. The debts and liabilities, that's considered too. The need for creation of new and future trusts. And also they consider minor children, even though child support, that's what child support does. But think about it.